Everything in our videos comes from experience. We hope our videos help someone. There are millions of people that have a learning disability, graduated from college, and have problems attaining meaningful employment. Because of this, they will never make enough money to pay off their student loans. For many, the following videos might help. For others, maybe this video will help. Video 1. Free money for college, start a business, people with disabilities and learning disability. Video 2. Federal law allows you to discharge your student loans after 25 years without filing bankruptcy. The link to our YouTube channel and our website is in the description below. All you have to do is expand the description and you will see all of the links. The National Institutes of Health. If you have a disability of any kind and file bankruptcy on your student loans or go to court, you will need the following information. The National Institute of Neurological Disorders and Stroke is part of the National Institutes of Health, NIH, and part of the U.S. Department of Health and Human Services. This federal government agency is the nation's medical research agency. They conduct medical research on almost every medical condition. If you want to get information about your medical condition that you can use in court, then go to their website. The National Institutes of Health is one of several federal agencies that support and conduct research on learning disabilities and disorders. Their research portfolio includes studies investigating the causes, development, neurobiology, prevention, and remediation of learning disabilities. The link to this website page is in the description below. All of these links are on our website. If you go to our website, you will find these links, documents that you can download, and links to other information that might be helpful. Such as links to the Americans with Disabilities Act, links to the federal government website on how to request accommodations for your disability, links to websites for learning disabilities, many documents that you can download. The National Institutes of Health's research states, research shows that 8 to 10% of American children under 18 years of age have some type of learning disability. So, what happens when they grow up, graduate from college, and try to get a job? The National Institute of Neurological Disorders and Stroke states, learning disabilities can be lifelong conditions. In some people, several overlapping learning disabilities may be apparent. Other people may have a single, isolated learning problem that has little impact on their lives. Learning disability, student loans and bankruptcy. You can file bankruptcy on your student loans. The process is not difficult if you know the procedure. The problem is the judges. We will talk about the judges in the section called court rulings. The process can take 1 to 2 years, and afterward, you might go through 2 stages of appeals, which can take 1 year. If you lose all your appeals, there is a law that will allow you to try again, but only if new information develops. The biggest problem is that most judges do not think that a learning disability is an actual disability. Getting past their assumptions is almost impossible, but it can be done. The one thing you must do is request accommodations for your disability. If you are granted the accommodation, the court now recognizes your disability, which you can use to prove your case in court. If you want to know how to request accommodations for your disability, please see my website and the page labeled Request Accommodations for Disability. This page will also help people know how to request accommodations for their disability at work and help employers understand what to do when someone makes such a request. This website page has links and downloadable PDFs. Student loans and bankruptcy. To discharge student loans, you must first file a Chapter 7 or a Chapter 13 bankruptcy and then file an adversary complaint. There are no additional court fees to file an adversary complaint. After this, you will go through additional court proceedings. Some states are easier to get a discharge than in others. Yet, in other states, it is almost impossible to get a discharge. The 7th Circuit Court covers Illinois, Wisconsin, and Indiana, and they have a reputation of being impossible. The 9th Circuit Court covers Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, Washington, Guam, and the Mariana Islands. The Second Circuit Court covers Connecticut, New York, and Vermont. The court's rulings from both of these circuits seem reasonable, but this does not mean easy. Other states that provide the more reasonable rulings are the states in the South, such as Alabama and Mississippi, or the smaller states such as Montana or Wyoming. On my website, I provided 20 court rulings where people were able to get their student loans discharged through bankruptcy. The website page is labeled Case Law, Bankruptcy and Student Loans. Court rulings. All of it depends on the judge. It does not matter if the judge is male, female, black, white, Asian, conservative, or liberal. Judges have their own biases and prejudices. To file bankruptcy on your student loans, you basically have to prove that for the next 5 to 10 years, you will not be able to make a minimum monthly payment. Plus, show in the past. 1. You have not lived an extravagant lifestyle while failing to pay the loans. 2. You have not intentionally created your financial hardship. 3. You have not willfully arranged your financial lifestyle to avoid your responsibility for the loans. Judges can do 4 things. 1. The judge can deny you a discharge. 2. The judge can discharge all of your loans. 3. The judge can discharge only the interest of the loans. 4. If your loans are not all consolidated into one loan, the judge can discharge a few of the loans and deny a discharge on the other loans. I have read a lot of court rulings where some were able to get their student loans discharged through bankruptcy, but many were not. The impression I got is the following. If you are black or a white male, you will have a very difficult time getting a discharge. If you are a white female, especially if you have kids, you will have a much easier time getting a discharge. For example, in one court ruling, a woman was collecting Social Security disability for over 8 years and sometimes worked a part-time job. The judge denied her a discharge because he said that the extra money she earned could have gone to pay her student loans. This ruling was 100% illegal, and she did not know how to file an appeal. Case Law Durrani v. Educational Credit Management Corporation states. The first prong of Brunner asks whether the debtor can maintain a minimal standard of living if forced to repay the loan, not whether she has any surplus income. Another woman who was bipolar, married, kids, she worked, and her husband worked. She was able to get her student loans discharged. However, she had enough money to hire a lawyer. Plus, she won every appeal. One would think that if you have enough money to hire a lawyer, then you have enough money to pay your student loans. The following are some of the most illogical rulings I have read. If you are 70 years old, some judges will expect you to keep working to pay your student loans. A judge stated that you applied for jobs beyond your ability. Thus, for this one judge, if you applied for any and all jobs that you might qualify will not get you the discharge. Plus, how does the judge know the job was beyond your ability? Now you know that a judge can twist the facts just to create a reason to deny you. A judge stated that your medical records are too old. Therefore, you have no disability. If you have a medical condition that you are born with, you will not get an updated diagnosis every year. A judge stated that your disability is not substantial enough to have prevented you from attaining employment to where you could not make payments on your student loans. Yet, your medical records in connection to your employment history show that the only job you have been able to achieve was labor jobs. No labor job is going to provide you with enough income to pay off your student loans. A judge stated that your income might be so low that you have to live with a family member. Thus, your needs are being met. Therefore, you do not qualify. Thus, the only way around this is to be homeless. A judge can twist the facts just to create a reason to deny you. A judge denied your request for accommodations for your disability because your disability is not substantial enough. Yet, your medical records state that you have a substantial disability. Judges are not doctors, but they can overrule a doctor's diagnosis. One thing you must always do is tell the judge that you applied for, were approved for, and received forbearances and deferments. If not, then the judge can say that you never made enough payments on your student loans. Therefore, you do not qualify for a discharge. Good luck. Best of luck.
Please hit subscribe or like. Thank you.